do.
On behalf of the Law School and the Church in the 21st Century Center, I'd like to welcome you all to this panel discussion entitled Catholic Faith and Cooperation in a Pluralistic Society, Navigating Conflicts Between Conscience and the Law. We have a very distinguished panel of lawyers and theologians, and to speak to this issue, which I think will be of interest to everybody who's here today. And it raises issues not just for people with concerns internal to the Catholic Church, but also concerns for anybody who wants to think about how to navigate potential clashes between what one's conscience demands and what the law demands. A little over a year ago, John Allen, who's the longtime Vatican correspondent for the National Catholic Reporter, said in a speech at St. John's Law School that the relationship of Catholic institutions to civil law that's in conflict with Catholic doctrine is one of the key questions that the Church has to come to terms with in the contemporary world. And he frames the question in these terms: to what extent will the Church, riding a strong wave of identity concerns, feel the need to disentangle its institutions from partnerships with humanitarian groups or government agencies for fear of complicity in values at odds with Church teaching? And even beyond that important institutional question within the life of the Church, I think the topic that we're going to speak to today really speaks to the question of what should individuals and institutions do when conscience clashes with the requirements of the law. The panel will address the ways in which the principle of cooperation, which is drawn from the tradition of Catholic moral theology, can help us think through the issues that face individuals and institutions that are striving to serve the public good in a complex world where law and policy are sometimes in conflict with deeply held moral principles. And that raises a range of questions that our panelists are well qualified to speak to. For example, what should a morally conscientious judge do when the law as the judge interprets it is unjust, and the action that the law requires of the judge in a given case is in conflict with the judge's conscientious convictions? Or what should a religiously affiliated social service agency with moral objections to contraception do when state law mandates that employers include insurance coverage for contraceptives? Or how should religiously affiliated hospitals respond to laws that require the provision of services that conflict with the hospital's moral commitment? The principle of cooperation provides a framework for thinking about issues like these, where the claims of conscience intersect with the demands of public service in a morally complex, pluralistic society. What I'll do now is introduce our panelists in the order in which they're going to speak, and then I'll let them come to the podium in turn to address the issue. The first speaker will be Father Jim Keenan of the Society of Jesus. Father Keenan is a professor of theology here at Boston College. Prior to joining the theology department, Jim was a professor of moral theology at the Weston Jesuit School of Theology in Cambridge, and he held the Gasson Chair here at Boston College from 2003 to 2005. He's a member of the New York province of the Society of Jesus and received his bachelor's degree from Fordham University, his MDiv from Weston, and did his doctoral work at the Gregorian University in Rome. Jim's teaching and research interests include fundamental moral theology, the history of theological ethics, the ethics of Thomas Aquinas, virtue ethics, ethical issues related to HIV/AIDS, and church leadership ethics. From 1988 to 1995, Jim served as a consultant to the National Conference of Catholic Bishops for the revision of the ethical guidelines for Catholic healthcare institutions. And most recently, Jim was the driving force behind a truly remarkable conference of moral theologians from all around the world that was held last summer in Padua, Italy. Our second speaker will be Father Russell E. Smith. Father Smith is the Senior Director for Ethics at the Catholic Health Association of the United States. And prior to that, he served as the Episcopal Vicar for Healthcare Ministry and Diocesan Theologian in the Diocese of Richmond, Virginia. He's also postulator for the cause of canonization of 8 Spanish Jesuit martyrs who were killed in the Tidewater region of Virginia in 1571. Father Smith is past president of the National Catholic Bioethics Center here in Boston, and he's taught and lectured extensively on medical ethics, and has written articles and edited numerous books in that field, and has served in various capacities of religious and priestly formation in both New England and Maryland. Father Smith attended the Redemptorist Alphonsine Academy and holds a licentiate and doctorate in sacred theology from the Pontifical Lateran University in Rome. And in October of 1995, Father Smith was invited to a worldwide meeting of directors of Catholic bioethics and family institutes sponsored by the Pontifical Council for the Family in Vatican City, during which he was invited to make an intervention regarding developments in healthcare in the U.S. vis-a-vis the papal encyclical Evangelium Vitae. Our third speaker will be Professor Edward A. Hartnett. Professor Hartnett is the Richard J. Hughes Professor of Constitutional and Public Law and Service at the Seton Hall University School of Law. After completing his bachelor's degree at Harvard, Ed went on to the New York University School of Law. And I'm confident that his Jesuit education at St. Peter's Prep in Jersey City gave him a solid foundation for all the academic accomplishments that followed. After receiving his JD from NYU, Professor Hartnett clerked for 3 different judges: U.S. District Judge Frederick Lacey, U.S. District Judge Robert Cohen, and Circuit Judge John Gibbons of the U.S. Court of Appeals for the Third Circuit. Professor Hartnett's service as a judicial clerk was followed by 2 years in the office of the Federal Public Defender in Newark, and then 2 years as a litigation associate at the Newark firm of Robinson, St. John, and Wayne. Professor Hartnett joined the faculty at Seton Hall Law School in 1992. His teaching and research interests include civil procedure, constitutional law, criminal procedure, evidence, and federal courts. And he joins us today having recently published an article in the St. Thomas Law Review entitled Catholic Judges and Cooperation in Sin. Our fourth panelist is Professor Kathleen Caveney. Professor Caveney is the John P. Murphy Foundation Professor of Law and Professor of Theology at the Notre Dame Law School. She earned her bachelor's degree from Princeton and holds her JD and PhD from Yale. Before joining the faculty at Notre Dame in 1995, Professor Caveney clerked for Judge John T. Noonan of the U.S. Court of Appeals for the Ninth Circuit and worked as an associate in the health law group here in Boston at Ropes and Gray. Professor Caveney's scholarship focuses on the relationship between law and morality, and in addition to teaching contracts in the first-year curriculum, she teaches seminars in the law school exploring the relationship between theology, philosophy, and law, and regularly teaches both undergrads and graduate students in the theology department at Notre Dame. Professor Caveney is a member of the steering committee of the Catholic Common Ground Initiative, which was founded by the late Cardinal Joseph Bernardin to help overcome polarization in the Catholic Church. And she serves on the advisory board of Notre Dame's Erasmus Institute, which focuses on deepening the engagement between contemporary scholarship and religiously based intellectual traditions. Professor Caveney is currently working on 2 books, the first entitled Casuistry and Prophecy, a case study in medical ethics, and the second, Other People's Wrongdoing, the Problem of Complicity. So as you can see, the panelists are well suited to speak to the issue of cooperation and conflict with the requirements of the law. Here's the order of how the presenters will speak. Father Keenan will first speak on the theological and historical sources of the principle of cooperation and the appearance of that principle in the ethical and religious directives for healthcare institutions. Father Smith will then speak to the practical application of the principle of cooperation in the healthcare context. Professor Hartnett will speak on the practical application of the principle in the judicial context, and Professor Caveney will speak to how we should situate hard judgment calls on the principle of cooperation within a broader view of the relationship of the Church to the world. So with that, I give you our panel. Thank you.
Thank you, Greg. I want to give 5 preliminary remarks and then just go to the handout. It's a 2-sided sheet that says the principle of cooperation in wrongdoing and my name under it. First, the principle of cooperation stems from discourse in the 16th century. The 16th century is a high point in the development of theological ethics because it's at this time that European expansionism finds itself encountering old principles that no longer assist in offering moral guidance for how to proceed. So as case in point is maritime insurance had been declared for 4 centuries morally illicit. It's the 16th century. You're going west, you're going east. You cannot afford not having maritime insurance. There needed to be a rethinking, and there was a dramatic rethinking of all of theological ethics. And for 100 years, there's this period in which it's all about the case method, a highly analogical, a highly inductive form of moral reasoning that you here at the law school would be familiar with. But it is not at all embodied in some sort of principle application to the case in terms of deductive reasoning. So the first is to say this principle is born as a result of the discourse in the 16th century. When the Council of Trent is held and seminaries are established, they have to have what we subsequently called moral manuals. These are the first times that we have textbooks available. And within the history of these textbooks, a variety of casuistic principles appeared. The principle of double effect. I love whenever anybody says, Thomas Aquinas gave us the principle of double effect. Not unless he lived in the 16th century, because it only came out after the 16th century. He lived in the 13th century, so he may have liked to have, but he didn't. The principle of toleration, the principle of minus malum, and the principle of cooperation. These are all principles that develop somewhere in the 17th, 18th, more likely at the end of the 18th century, and then become more applicable deductively in the 19th and 20th century. So it's important to grasp that these principles are really putting together the least common denominator of analogous cases. That just as the principle of double effect is taking in a variety of cases that the casuists had solved in the 16th century, in the 17th century they distilled these cases into more programmatic principles that then become the fodder of the great moral manuals that are subsequent. So that's a whole history of theological ethics in 2 minutes. So. The second is there is a wide array of interpretation about the principle itself, a wide array of interpretation that cannot be overly emphasized. Even the title I have, the principle of cooperation in wrongdoing. Edward has been doing work on the principle of cooperation in sin. Did I hear you say sin in your presentation? I don't know what. Well, you're talking about partnerships, so that's something else. But you can hear somebody, even the title of the principle. Is it cooperation in evil? Is it cooperation in sin? Is it cooperation with wrongdoers? Is it cooperation in wrongdoing? So even the title bears a variety of results of different interpretive forces. For instance, in these manuals from the 18th and 19th and 20th century, it depended if they were written by Jesuits or Dominicans or Redemptorists or your secular clergy, because each of them had a different hermeneutics for interpreting this principle, some more pastorally, some more leniently, some more strictly. So the second point, wide array of interpretation about this principle, even to not only its title, but as I'm trying to do today, I'll go right through these different points of the principle, but as soon as I do, my friend Russell here and my friend Kathy here will automatically disagree with certain words and concepts and how I employ that. That's the nature of the beast. Third, just as there's a wide array of interpretations, there's also a wide array of application. Bernard Herring, the great Redemptorist moralist, said, no layperson can get through a day without the principle of cooperation. I just think taxes. Every time you pay taxes, inevitably, you are doing some form of material cooperation, unless we live in a completely pure, sanctified government that is completely untouched, and at least it hasn't been today. So this third point on the wide array, speakers on campus. You know, this is a big thing this week. You know, there's all these different litmus tests for what is appropriate for a Catholic university to do. This week we're discussing speakers on campus. Well, actually bringing on controversial speakers is a way of cooperating in whatever they're doing that we disagree with. And that act of cooperation is an institutional act when it happens, for instance, at a law forum, or when it happens when we give an honorary degree, as we've done before. We've seen these as instances of material cooperation with evil, with sin, with wrongdoers, whatever, but with some form of material cooperation. So a wide array of applicability. Fourth, until recently, the principle was used basically about persons and their relationships with institutions or with other persons. There's been a considerable innovation to recognize that this principle could be used also for institutions. That does not mean that institutions were not already involved in cooperation, but our actual use of the principle and our invoking the principle to describe, say, Boston College's relationship with an organization, say like Amnesty International, could be construed as an institutional cooperation with evil. So that's the fourth is it had been considered basically applicable to persons, and in this past 20 years, really, we moved toward more institutional applicability. For instance, when an archbishop shows up on a Republican platform to endorse a candidate who may be very pro-life but also pro-war, they exist, that is an institutional act inasmuch as he is a bishop representing his diocese and is more than a personal individual. He's a social representative of the church there. And the fifth introductory point is, you'll hear this phrase, so I figured I might as well bring it, is the ethical and religious directives. These directives were published in 1995. There are roughly 70 directives in this. These directives were worked on for 6 years. I was one of the members of one of the two draftsmen. And this went through 12 editions before it was finally agreed on. And one of the funny things, that's a long story which we won't go into, but in the very first edition, the principle of cooperation appeared, and then in the fourth edition, it was deleted, in part because we were all having arguments as to whether or not, that second point I made, whether or not its own articulation is something we can all agree on. So it gives you an idea of where we are. So let me say something in about 7 minutes on this by just simply going through this sheet, because I figured in order to have some conversation about this, it would be important to at least know what are the constitutive components of the principle. I first got involved in this in 1988 when the Many Faces of AIDS came out. This was a statement that came out from the administrative board of the Conference of Catholic Bishops in Washington, and Cardinal Bernardine really ushered this document through. And in the document, he said, the Many Faces of AIDS said, that if you had a person who is HIV infected and you have a healthcare worker in a Catholic healthcare facility, and that healthcare worker says to this person who's been notified of, say, his status, that he is HIV infected, the healthcare worker should recommend that he be abstinent. And if he says that he's not abstinent and has no intention of remaining abstinent or being abstinent, then the healthcare worker can say, then use a condom to protect the common good. And then they invoke the principle of toleration. And then all hell broke loose. We had 4 cardinals denouncing the document, saying they're going to teach it in their diocese, and a great brouhaha. And when they did this, I entered it by saying, you know, not for nothing, but it's not the principle of toleration, it's the principle of cooperation. Toleration you simply permit. For somebody to advise somebody to use a condom, that act of advice giving, that is a participation in the other agent's wrongdoing. I did argue that this was very ethical advice to give, so I want to make that clear. But I used a different principle, the principle of cooperation, to do that. And I think that from that point on, that article is actually somewhat foundational for what Russell will say or what Kathy would say. I'm not yet familiar with Edward's positions, but we've been involved in discourse on cooperation now for, I'd say, almost 18 years, and it started at that point, if I have history right. The principle then differentiates the action of the wrongdoer from the action of the cooperator through two major distinctions. The first is between formal and material cooperation. Formal cooperation is basically about intentionality. It's not about the actual performance of an act. It's simply about the subjective stance of the agent, of the cooperator. Formal cooperation is when the cooperator intends, affirms, or approves the wrongdoer's activity. This is evidently always wrong. If you intend the wrongdoer's activity, then you are intending the wrongdoing, and therefore it is wrong. Since intention, however, is not simply an explicit act of the will, formal cooperation can also be implicit. There's a misprint there. Implicit. Implicit formal cooperation is attributed when, even though the cooperator denies intending the wrongdoer's activity, no other explanation can distinguish the cooperator's activity. So what we're always looking for is that the intention of the cooperator has to be different from the intention of the wrongdoer. I mean, that's key. The intention of the cooperator has to be different from the intention of the wrongdoer. The cooperator is involved for some other reason than the intentionality of the person who is performing this act of wrongdoing. If the wrongdoer then does not intend, affirm, or approve the wrongdoer's activity, then the cooperator's activity is called material cooperation, and this can be morally permissible. Now, one little aside here is, if you are involved institutionally in somebody else's wrongdoing, are you really required not simply to refuse to affirm or approve, but do you also have to actively disapprove of it? And this is something that is constantly open to discussion. The second distinction deals with the intention, not with the intention, but with whether we can in fact differentiate the activity of the wrongdoer from the activity of the cooperator. And this distinction uses the concepts immediate versus mediate material cooperation. This, I saw even on our sheets, you'll see that Russell and I already disagree on one point, and it's this. Immediate material cooperation is when the object of the wrongdoer's activity is indistinguishable from the wrongdoer's. I spoke a little too quickly. We agree probably on the definition. Its applicability is somewhat different. It's almost always wrong, but certainly it is never permissible when involved in the direct death of innocent human life. But immediate material cooperation would be when you cannot distinguish the cooperator's activity from the wrongdoer's activity. Classic examples. They love the case of, the manuals love the case of the servant. The servant wants an assignation with his mistress. Gives the servant a letter. All the servant is doing is carrying a letter to the mistress to set up this rendezvous. Now, of course, the letter is somewhat important, and the servant may well know about the letter, and he's carrying it, and this is that his action of carrying a letter is different from the romantic liaison that's going on between this man and this woman. It's differentiable. They have all this about, in medical ethics, a nurse or an anesthesiologist is performing certain responsibilities that you can differentiate, for instance, from when a physician performs a procedure that, say, the church or some other institution consider an illicit procedure. So this is really a question about being able to differentiate the activity of the cooperator from the activity of the so-called wrongdoer. Mediate material cooperation means that the object of each one's action, therefore, is distinguishable. And that's what we're always looking for. So the first point, we're looking to distinguish the intentions, and now we're interested in distinguishing the realm of activity that's occurring. If it's mediate material cooperation, then there are three basic questions that we have to determine whether or not it's basically moral. The first is the immediate material cooperation remote or proximate? That's, again, a kind of reflection basically on whether or not the cooperation is immediate or whether it's sufficiently mediated. The second is there proportionately grave reason for the immediate material cooperation? The word duress appears often here. Duress means that one of the proportionally grave reasons might be that you have no other choice but to do this. This can happen in any sort of ways. It could be like Patty Hearst being a captive and having to rob a bank with a group of other persons, so she has no other choice but to be there, and so under duress she's cooperating, otherwise she may well be gunned down. It could also be that the existence of a healthcare institution might be jeopardized. For instance, in Australia, many of your hospitals receive their charters as a sole provider in an area, and they might be required to provide therapeutic sterilizations, which are against church teaching, and yet the only way they can provide the general care that they're doing is to work out this fact that otherwise they will cease to exist. So the word duress usually enters into this, but not exclusively, to describe proportionally grave reason. Finally, there is always the question of scandal arising from immediate material cooperation, but what many of us like to warn is that scandal can cut either way, or both ways. In other words, there may be scandal about not cooperating, there may be scandal about cooperating. So, for instance, you could think of a speaker coming to a campus, canceling the event may be more of a scandal, or by actually holding the event, it may be more of a scandal. But the question of scandal, we should always realize, cuts two ways. Thank you.
I segue right into this by talking about our institutional involvement and the experience of Catholic healthcare throughout the United States. At this moment, about 18% of all healthcare facilities are Catholic or related to the Catholic Church. So we have a large stake in this, but it's spread out, not just all over the country, but in every conceivable configuration, in the sense that until recently, just about every hospital, Catholic or otherwise, was a standalone institution. By that I meant it was not affiliated with any other hospital in town, and not generally affiliated with any large geographical province, say, unless it was with a religious order like the Daughters of Charity. And the Daughters of Charity did have, and the Sisters of Mercy had the two largest systems, as we came to call them eventually, in the country. But they were large orders running a lot of health care. And in the 1970s, just to talk about the difference maritime law introduces into moral theology, the way that healthcare delivery has evolved has forced us to keep abreast of developing civil law and always G'ing that with the canon law as well. So in the 1970s, which is a long time ago, but nevertheless most of these outfits were standalone. And we think that religious orders have owned hospitals forever, and that's not really true. The first hospitals that were certainly in Europe and in this country may have been owned by a religious order, but many of them, particularly city hospitals, were owned by the Crown and staffed at the invitation of the Crown by religious orders. That's true of the first hospitals in the New World. The first hospital built, I think it was 1512, the Hospital of the Immaculate Conception of Mexico City, was done so at the request of the Crown, Spanish Crown, and Cortez built that. The first hospital in Canada, the Hôtel Dieu, was done so by the French Crown at the behest of Cardinal Richelieu, who sent his own niece over to work in that hospital as I think an Ursuline nun. So ownership in fact, is new. And the Daughters of Charity actually had a member of their community on the front page of the New York Times Sunday magazine because she was the CEO of the 4th largest not-for-profit corporation in the world. And she became known in the Wall Street Journal as the daughter of currency. So, in the abortion sort of raised the legalization of abortion in the 70s raised great questions of institutional integrity, because there was this suggestion in Washington that we may have to commandeer certain hospitals that are otherwise opposed to abortion and commandeer them to provide for this if they're the only hospital in a given area. So there was a great sense of uncertainty in the legal forum. In the 1980s, it was recognized that the religious were disappearing who staffed the hospital. Perhaps even today, in the minds of many, the idea of a Catholic hospital is a nun who generally there's a nun on every floor, on every ward, on every shift, and they are the supervisors, and that is not the case at all. Through the 70s, 80s, and 90s, we have seen the gradual disappearance of particularly religious women from the wards, and then from administration, now slowly from the level of the boards, and now from the top administration, which we call sponsorship. The originally sponsoring congregation, say, of the Carney Hospital here in Boston, was Daughter of Charity. It's not even a Catholic hospital anymore, but they evaporated from the bottom to the top. And this is something that we are now working, all of us, with this window of opportunity in handing on the tradition of Catholic healthcare, which is as old as the Church itself. So in the 1980s, the corporations, say regional mid-Atlantic groups of Catholic hospitals, began to form larger partnerships, particularly in light of the disappearing religious. And so we had eventually from corporations to what we call systems. And these systems are known by names like Ascension, Catholic Health Initiatives, Catholic Health West, Catholic Health East, and the like. We have a local system here, which is strictly the New England area, probably just Massachusetts, and it's Caritas Christi, the flagship of which is St. Elizabeth's Hospital down the street. In 1983, the Code of Canon Law was revised and promulgated. Book 5 of the Code of Canon Law deals with the temporal goods of the Church and how they're to be administered, how the patrimony of the Church is to be protected, and how alienation from that patrimony is to be effected. Well, in the following year, it took a while for no one knew what was going to be in the final Code of Canon Law, so it took about a year for literature to come out on how to structure American civil corporations that will work hand in glove with the Code of Canon Law. One of the most influential was by a team of a priest, now Cardinal Maida, and Caffardi, who is from the law school at Duquesne. And so they came out and said, basically, we recommend that healthcare not follow the example of many universities, Catholic universities. We recommend that you create a corporation, a membership corporation, in which sponsors, namely the nuns, the religious, will have certain reserved powers over the philosophy and of the mission, its discontinuation, the appointment of directors of the board, and the at least the CEO, if not other major corporate figures. That's the largest amount of our hospitals are involved in that. There are other little things that tend to lessen the grip on the mission as time goes on, and so this has been found to be very effective. As I say, we have moved from a position of individual institutions or individual congregations of men and women who what we call sponsor the ministry or the apostolate. And we've moved from that to a set of sponsors that are somewhat removed from the boards of directors. And now, with the disappearance of religious entirely in some groups, we have moved to the creation on the ecclesiastical side of the ledger of the public juridic person. That public juridic person, it's like a corporation, and but analogously, not exactly. The public juridic person endows the ministry with its Catholic identity. And so the naming of the boards is very important. One final thing I'll say as a preliminary note, which probably would be half the talk, but nevertheless, Kathy and myself and Jim have been for the last 7.5 to 8 years involved in a gathering of theologians, healthcare providers, and others, multidisciplinary, talking about the principles of cooperation. It's been a long, tedious process, and I can't put any more accurate words on that. However, as much as we disagree over the words, I'm happy to tell you that not one case that we examined did we disagree on the appropriate or inappropriateness of that particular case. So we're affirming basically the moral insight, if not the moral line of reasoning, by which we get from point A to point B. Now, philosophers don't like to talk about intuition, but that's their problem, and they're not here. Okay, so basically, getting to the principles of partnership, Jim mentioned one of his main preliminary points was the fact that the principles of cooperation were devised to study individuals and their moral action. We are now dealing with corporate individuals, so there will be a certain sameness and a certain unsameness. It's the movement on of maritime law from the Middle Ages to the Renaissance. And we're seeing this development of doctrine, if you want to call it that, before our very eyes. We're saying basically, when corporations come together, and the Daughters of Charity National Health System, for example, wants to partner with another group that's not Catholic. There is any number of cases where two hospitals will come together in a given jurisdiction because they realize that the competitive model of healthcare doesn't work, that they have to not overstock this town with 2 MRIs, the duplication of services. It has to be, we don't call it rationed, we call it rationalized, where one campus will highlight cancer treatment, heart treatment on another campus, neurology over here, psychology over there. You have to reduce your staff in order to contain costs, and this competitiveness was just not working. So when we come into contact with another non-Catholic hospital, which is very frequently the case, that you will have a 2-hospital town. I worked with a town in West Virginia, a little coal town. Sacred Heart was on one end of town and Community Hospital was on the other. They can't exist together. They come together, and what do they have to agree on? From our side, we say that from the articulation that Father Keenan gave, cooperation must be mediate material cooperation, or material cooperation, let's call it, not formal cooperation. And in the event, as he mentioned, of the taking of innocent human life, it can't even be immediate material in those sorts of cases. Second principle, we only do together what all the partners agree is appropriate. This means that while the alliance or collaborative effort need not be Catholic, it must nevertheless observe those ethical and religious directives as respecting the corporate conscience of the Catholic partner. Now, we'll come together to do only what we all agree to do. Now, it doesn't necessarily have to exclude a service on moral reasons. It could be financial reasons. Catholic hospital and Methodist hospital might want to come together, but Methodist hospital knows the Catholic hospital is downtown and its emergency department is hemorrhaging money. So it wants to exclude that emergency department from the collaborative effort that otherwise Catholic and non-Catholic will be doing together. So this doesn't necessarily imply moral superiority in every sense it could just be good business, or just the personal chemistry of who's in Baltimore at the time. Morally illicit procedures cannot be provided on the Catholic campus. Well, where are they provided? They're provided on the other campus, and they're carved out. They're provided on campuses of non-Catholic alliance partners, must be excluded from the new alliance corporation through separate billing mechanisms, administration, and governance. This is not as easy as it looks, but it has worked. And then finally, getting to the point of scandal, I am reminding, the first thing I will tell an administrator who's going to make an announcement that we're going to have a go with Methodist Hospital is to smile and remember this is good news. And you're doing this for the good of the health of the community, number one, and the common good. So that's a pretty darn good reason to be happy about this, no matter whose face got scratched off in the boardroom. So all publicity, and a PR problem is not necessarily scandal. It could just be a PR problem. But all publicity about a proposal should be straightforward regarding the need to form an alliance, that is the good to be done, the good achieved by rationalizing health care, driving down cost and improving public health, the exclusion of immoral procedures from the partnership, even if these services will be available on the other than Catholic sites, and the necessity of this publicity appearing also in the promotional literature throughout the new corporation. So that's how we're trying. This is the template that we try to assist Catholic sponsors with in bringing healthcare to a given region. Okay? Thank you.
I'm excited and honored to be here at BC, but frankly also a little bit intimidated. I am a law professor. I'm not a theologian. I'm a bit of an outsider and a newcomer to this whole question of cooperation. When I first started, for a variety of reasons, being interested in the question of what should a Catholic judge do when confronted with a conflict between faith and law, it began to dawn on me that what I really need to learn and focus on was the doctrine of cooperation, and I was quite convinced and sort of affirmed that I was on the right track when I came across a line from Father Keenan that the doctrine of cooperation, quote, provides a paradigm for the modern Christian who seeks to make the world a better place by neither compromising values nor detaching oneself from a world ridden with complexities. So having been encouraged by Father Keenan, I'm now a little bit intimidated being on the same panel with him. Because I'm sure there are going to be lots of ways in which those who know a lot more about theology than I will be able to correct me here. But there are a host of areas, of course, where Catholic teaching and American law are at variance. I mean, some of them have been alluded to already, include contraception and abortion. Death penalty is another one. Marriage is another one, where the Catholic Church views marriage as permanent, and civil law basically views marriage as an at-will contract. But in addition, Catholic teaching about the universal destination of human goods, the property held subject to a social mortgage, a preferential option for the poor, the duty to welcome aliens, selective conscientious objection to particular unjust wars, all of those are at variance with American law. But sometimes the conflict isn't as real as it might otherwise appear. That is, that the Catholic tradition has never insisted that all things that are wrong, that all sins be made illegal. Prudential considerations come into play before it's appropriate, even under the Catholic tradition, to make something illegal. And of course, many Catholic judges have conscientious views that vary from church teaching. If that conscience corresponds to the law, then the conflict that I'm focused on today is not of concern. What I'm focused on is sort of assuming a judge whose conscience is in accord with with Catholic teaching, or perhaps more generally, any conflict between a judge's conscience and the duty of what the law calls for in a given case. Judges can categorically only avoid that conflict, the conflict between a legal judgment and a moral judgment, if they somehow think that the law equals morality, either by viewing the civil law as the ultimate determinant of morality, or by viewing adjudication as a license to interpret the law in whatever way is necessary to make it accord with the judge's conscientious moral views. The first position, that is that the civil law is the highest moral authority, is certainly impossible for any Christian to hold, given what the civil law did to Jesus. And anyone who holds the second position, that views adjudication as a license to do whatever you think is morally right, this talk has nothing to say to you. This might be a good time to take a break. What I'm concerned about is where there is a real conflict, and it seems to me that any judge who believes that ascertaining the law is meaningfully different than ascertaining that judge's own moral views, and doesn't view the civil law as the highest moral authority, has to acknowledge that there is the possibility of a conflict that is, as John Courtney Murray liked to put it, two there are. A judge can't simply blink this possibility of conflict. I want to focus on a couple of applications in the legal context, but before I do that, I want to add with some trepidation a couple of thoughts about cooperation to Father Keenan's general discussion. And the reason I think that's worth doing sort of as a novice is that sometimes the novice can say things that the expert takes for granted and thereby help other novices. So let me sort of say a couple of things along those lines. To modern ears, certainly to modern lawyerly ears, the formal material distinction seems exactly backwards. Why is formal cooperation worse, and why is material cooperation not necessarily wrongful? That's not the way lawyers tend to think. Form is, that's just a matter of form. Material is what really counts. Genuine issue of material fact. Evidence is material. To get a handle on the terminology, I found it helpful to remember sort of where it comes from, or at least where I think it comes from. That is to go back to Aquinas, go back to Aristotle and their metaphysics. That is, what a form is what something is in its essence. The essence of something is its form. The matter is simply the stuff that it happens to be made of at the moment. So a human being has a particular form. The particular molecules that make up that person are simply the matter. If you understand it that way, then formal cooperation in sin is sort of the essence of assisting another, while material can be thought of as not the essence of such cooperation. I found remarkably helpful as an outsider trying to get a handle on this doctrine, these old-fashioned manuals of moral theology. And from a lawyer's perspective and from a law student's perspective, what are these things like? They're like horn books. In the same way that cases are basically inductive, the manuals are like horn books. They're more deductive, sort of stating principles and showing particular applications of them. Indeed, I've been told that moral theology exams in seminaries prior to Vatican II sounded an awful lot like torts exams, but rather than find the torts, it was find all the sins. But one of the advantages that, at least as an outsider, that I found in going back to these manuals, because of their deductive nature, because of their horn book-like nature, is that they put categories together. That is, particular topics connected to broader topics. So in the same way that it can help to learn a particular legal subject by looking in a horn book to see how it fits with related topics, it seemed to me that the same thing was true with regard to cooperation. That is, that it's treated of as an aspect of charity, as an aspect of fraternal correction. That is, duties that one owes to another to help one to avoid wrongdoing. And viewed from, why do I think that's a useful perspective to bear in mind, is because it makes clear that what the doctrine of cooperation is about not misleading another, not helping another to do wrong, as opposed to the way it sometimes appears when viewed in isolation. It's not a doctrine about keeping one's own hands clean. It's not a doctrine designed to keep my hands clean. It's a doctrine designed because of one's obligation to not contribute to another's downfall. Okay, with that little bit of addition, let me turn to judges. It seems to me that the daily grist of many judges' decisions involves material cooperation. That is, because what judges are doing is resolving disputes between fallen humans in conflict with each other, there will be ways in which, no matter what they do, or at least frequently what judges will do, will be helping someone do wrong, whether that's acquitting a guilty defendant because the evidence wasn't sufficient, or entering judgment for a plaintiff who's lying, but the jury nevertheless believes the plaintiff. Whatever it is, there are lots of actions that a judge takes that can be helping someone to do things that are wrongful. But in those situations, it would be extraordinary, I think, to be condemning the judge for having done anything wrong, and certainly extraordinary to think that the judge was engaged in formal cooperation, that is, engaged in that the decision was designed to produce that end, that the judge was trying to acquit a guilty defendant in order that the defendant go out and commit more crimes, or to unjustly enrich a plaintiff because the plaintiff was lying but believed by a jury. Let me turn to a couple of particular examples. Dean Garvey co-authored a piece with Amy Coney Barrett a few years back, looking at the question of cooperation in the context of the death penalty. They concluded that for a judge to sentence a defendant to death constitutes formal cooperation in the evil of the death sentence, while reviewing that death sentence on appeal or on collateral review, such as habeas corpus, involved permissible, or at least arguably permissible, material cooperation. They're certainly right to sort of carefully distinguish between different acts that a judge takes in different kinds of cases. I'm not entirely sure that they're right about that the imposition of a death sentence is always formal cooperation. That is, I think that is at least possible conceptually for a judge to enter an order authorizing the executive to execute someone without intending that order to be carried out. That may be not terribly frequent, but I think it happens. Occasionally judges will enter orders and then suggest to the executive that the executive not carry that out. There's also some basis in the tradition at the time when the death penalty was widely accepted, and the key issue was, well, what about the condemnation of the innocent? And there's reason to think that for both Aquinas and Alphonsus, the patron saint of moral theology, that the wrongdoing shouldn't be thought of as the judge's wrongdoing, but rather those who provided the untrue evidence that led to the conviction of the innocent. But that's a sort of minor point there, because even if the entry of a death sentence is not formal cooperation, I think it's rather clearly close material cooperation, unless there's a very, very good reason for a judge to engage in that. It seems to me that a judge should not. How about the abortion context? This is an area that Dean Garvey did not address. What I'd like to suggest is that at the most general level, a judicial decision that determines the legal allocation of power is not necessarily formal cooperation in the sins of those to whom the law allocates that power. That's easiest to see in the example where there is simply no statute on point. Right? Imagine an assistant U.S. attorney filing a criminal complaint against Planned Parenthood for performing first trimester abortions. Well, a judge is going to dismiss that complaint rather handily because there is no such federal statute criminalizing that act. I think it's easy to see that a judge need not be engaged in formal cooperation in dismissing that action. While the legal questions get harder as you present questions such as there is a federal statute, but is it constitutional? Or there is a state statute, is it constitutional? Or even the question for Supreme Court justices about whether to adhere to Roe and Casey or overrule them. I think the basic principle holds true. That is, it is not necessarily formal cooperation for a judge to conclude that the way the law allocates power to make a decision is to the states rather than to the national government, or is to the woman rather than to the state. That need not be a matter of formal cooperation. It depends on the judge's intent, whether it's formal cooperation. One, of course, then needs to turn to issues of material cooperation, because it certainly is material cooperation, with a host of factors that go into deciding the permissibility of material cooperation. Basically, is the good that's being achieved by deciding a case in accordance with the law a sufficient reason to accept the bad side effect that comes along with that. And it seems to me that a crucial factor here that needs to be focused on is the question of scandal. That is, in theological terms, the risk that others may be misled. That is, that others may be misled into thinking that something that is wrongful isn't wrongful. Right? Here's another place where the terminology is confusing to an outsider. Certainly was confusing to me until I delved into this material. That is, that scandal in common parlance is sort of embarrassing bad act that is revealed to the public. But scandal in Catholic moral theological terms isn't that, but rather is the risk that your action will lead someone to do something that's wrong, typically by a good person providing a bad example. And that focus, I think, is quite important to bear in mind in determining the propriety of judicial actions. I think there is one category of cases that Catholic judges shouldn't be deciding, and that is abortion bypass cases. That is, it's very hard for me to see how any judge can decide that an abortion is in a minor's best interests without deciding that that is what should occur. So it seems to me in that limited context that there is almost certainly formal cooperation involved, and therefore a judge should not be participating in those. Well, what then does a judge do? So in terms of the legal side of this, I think the right answer is the one that Chief Justice Roberts was reported to have given, but it's not clear whether he actually gave. That is, what do you do if the law requires a judge to perform an act that is wrongful? I think the right answer was the answer that he was reported to have given. That is, that you recuse from deciding the case. That is, that the basic test for whether a judge can sit in a case is whether that judge's impartiality can reasonably be questioned. And it seems to me that a judge who can only decide a case one way, a judge whose approach to a case is, as a moral matter, I can only decide a case one way, that's someone whose impartiality under the law can reasonably be questioned, and therefore recusal is appropriate. Some have argued that a judge who finds him or herself in this situation has to resign rather than recuse. Justice Scalia has suggested that that's true. That is, if he were to accept current teaching on the death penalty, that he would have to resign. Some critics of judges who have recused from abortion bypass cases have said the same thing. It seems to me that that's only true if the number of instances of recusal is so great that that either you're not doing your job or you're not doing the fair share of your job. But if the instances of recusal on moral grounds is no different than on the impact on other judges, the impact on carrying your weight, then recusals for other reasons, such as ownership of stock in various parties before the court, or having relatives who are lawyers, if the recusal for moral reasons is no greater than recusals for these other reasons, it seems to me that resignation is not called for. For most judges, these kinds of cases are not going to come up very often. Somewhat oddly, it may be that the toughest position to be in these days is actually a Supreme Court justice, because Supreme Court justices are involved in virtually every death penalty case in the country, at least once their sentence of death is imposed. That may suggest why Justice Scalia's thinking is where it is. That is, he, particularly as the Circuit Justice for the Fifth Circuit, he's dealing with death penalty cases all the time. The very frequency of those may make it more significant, may make the impact on him and the impact of his doing his job more significant. Others have suggested that maybe what a judge should do is simply decide the case in his or her own mind, and then if the legal conclusion conforms with the judge's moral conclusion, then decide the case. But if it doesn't, then recuse at that point. That's maybe tempting, but I don't think that's right either, because if going into a case you can only morally decide it one way, it seems to me that your impartiality can reasonably be questioned. I've taken too much of my time. I just want to end with one thought, and that is that I would urge all of us to be focused particularly on the question of scandal in the judicial context, because it seems to me that that frequently when people complain about judges being honored or judicial decision making, what they're really concerned about is the risk of scandal. And I would urge people with those concerns to focus on that concern rather directly, emphatically, and clearly, probably using a more accessible term than scandal, and perhaps even suggest particular ways for judges to avoid the risk of scandal.
Good evening. The trouble with being last is all your good points have been taken, basically. So I will try not to repeat anything that has been said, and maybe you'll get a shorter talk out of it. So what have we done so far? We've had Father Keenan introduce you to the principle of cooperation and its many moving parts. We've had Father Smith apply this to the contested and difficult context of Catholic health care. We've had Professor Hartnett apply it to the even more difficult, although not quite yet as contested, context of judicial decision-making. What's left for me to do? Well, what I want to do is step back for a second and ask why it matters. What's at stake in this? And what's the theological, the vision of us, our relationship to God and our relationship to one another as made in the image and likeness of God, issue, question, situation that's at stake in cooperation? But first I just want to say two things, just to situate the theological discussion. Many of you here are law students, a lot of law students? Okay. Well, I think it's important to remember that while all of these abstruse terms of cooperation may seem unfamiliar to you, the problem and its difficulties are not. You may have taken criminal law in your first year of law school, at least we teach it at Notre Dame, and I'm sure you do here, and you've probably come across questions of accessory liability or conspiracy liability, and trying to figure out when one agent's contribution to the wrongful act of another actually qualifies that person as an accessory, or may even under certain circumstances qualify them as a co-conspirator. One of the cases I recommend you read if you're bored tonight is a case called People versus Loria, a 79 California case, where there was extended and contorted discussion about whether a telephone answering service that took messages for a ring of prostitutes, a ring of call girls, was actually guilty of conspiracy to commit prostitution. And lots of the questions that that case looked at, well, what were they doing? Were they intending to further the prostitution? Should they have known that, they were providing something that was only essential and was only good for that particular type of business? Those types of questions that you've heard talked about today are questions that we lawyers look at when we're looking at whether or not somebody is either an accessory or a co-conspirator to a crime. So that's the first thing I think it's important to keep in mind. Secondly, I think it's important to take the right attitude toward the moving parts of the wheel of cooperation with evil. We've gone through many categories. Is the cooperation formal or material? If the cooperation is material, is it immediate material or mediate material? If it's mediate material cooperation, is it remote mediate material cooperation or proximate mediate material cooperation? Some people will look at all of these subcategories and just shake their heads in disgust, saying that this is just mere legalism. How can you get to any kind of moral judgment when you've got all of these moving parts and subsets of categories applied to the complexity of real life? Other people, in my experience, look at this and say, no, it's not like the tax code. It's like TurboTax. It's a moral TurboTax program. I'm going to run my moral problem through the moral TurboTax problem, and I'm going to get an answer, and it's going to be a good answer and the right answer, and there's going to be no dispute about that answer. Well, the best way to think about that problem, I think, is to say, no, this isn't a tax code, and it isn't a TurboTax program. The principle of cooperation and all of its moving parts are tools for moral discernment. They can aid moral wisdom by directing you to certain questions you need to look at, but they can't replace moral wisdom. And what you need to remember then is that you need to approach the tools as a complicated set of tools because the problems are complicated. Why are the problems complicated? Life is complicated. So that's the basic framing of my three questions that I'd like to look at very briefly. What are those three questions? First, why is cooperation with evil a problem in the first place? Second, what's the background theological framework against which we decide how close is too close to cooperation? And third, what are the special problems in applying the cooperation framework today? So let's start with the first problem. Why is cooperation a moral problem? Why do we care? Well, there are some good answers. You could say, well, cooperation with evil is a moral problem because it involves a type of intentional wrongdoing. And certainly that's the case. Formal cooperation, at least, not material cooperation, but formal cooperation is a type of intentional wrongdoing. If I give you a gun intending you to go shoot somebody else, I'm involved in intentional wrongdoing. Second, you could say that it's wrong because it involves a contribution to someone else's sinful act. They're committing a sin, I'm contributing to their sin, I'm helping alienate them from God, that's bad. Third, many cases of cooperation that are around today, especially the ones we hear about, are worried about, in the case of abortion or euthanasia or some of these, stem cell research, the things you see in the New York Times and read about in the diocesan papers, are worried because we're worried about cooperation that involves harm to innocent third parties, vulnerable third parties, torture. They may not be innocent in the sense of innocent and pure, but they're innocent from the sense of that Catholic moral theology requires, which is you can't do that type of harm to somebody that's non-aggressing, that's vulnerable, that's not immediately aimed at you. So if we're supporting torture indirectly, we're involved in cooperation with harm to innocent third parties, different from abortion, but still same category. And fourth, you can say that we don't like cooperation because you can stop bad acts if you refuse to cooperate. If I don't give you the gun, maybe you won't go shoot somebody. I think all of those are true reasons for not cooperating. I don't think they're the only reasons for not cooperating. We're not worried, for example, only about intentional wrongdoing. That's formal cooperation. We've talked a lot about material cooperation, which is when you foresee but do not intend that your act is going to make a contribution to somebody else's wrongful act. Now, here's another distinction that lawyers need to, I think, pay attention to. The definition of intention in the Catholic moral theology world is not the same as it is in many aspects of the legal world. In the Catholic moral theology world, you do not necessarily intend all the foreseen consequences of your act. Intent is defined in, not necessarily to encompass all foreseen consequences. That's why there's this notion of the principle of double effect. Sometimes in law, we tend to equate the two. Can't go into it here. That's another seminar and maybe another trip to Boston, but just lawyers flag that for your future use. Second, cooperation isn't just about contributing to someone's sinful act. We worry about it even if the person involved is not sinning. There was a debate in the 60s and early 70s. Well, we're cooperating with somebody who thinks they're doing the right thing. We're not cooperating with somebody who knows they're doing the wrong thing. If you're selling, say, contraceptives, that was a big issue way back then in terms of the debate. They don't think they're doing the wrong thing. And so then we're not cooperating with their sin, because sin requires, a sense that you're doing something wrong, or something that you ought to know is wrong, not, a kind of invincible ignorance about the wrongfulness of your act, or a justified ignorance under some circumstances. But we worry about not only contributing to sinful acts, we worry about contributing to objectively wrong acts. We argue about what they are, but we don't just worry about sin. We don't only worry about cooperation with evil when there's an innocent third party involved. So abortion and euthanasia and stem cell research are all cases of cooperation with evil, but you need to worry about cooperation with evil if you're giving somebody a means to harm themselves. Somebody's going to go out and, drink or do drugs or, do something that they shouldn't do that's going to harm them. We worry about that as well, even if the only harm is to their own souls. And moreover, and I think this is important to remember in our pragmatic society, we don't only worry about cooperation in cases where our cooperation is a necessary cause to somebody else's wrongdoing. There's a subcategory that's also part of the big matrix, the wheel of categories of cooperation with evil. It says, is cooperation necessary or free? And what that gets at is, if I don't do my act of cooperation, will I stop the primary bad act from occurring? That's a relevant factor, but it's not the only relevant factor. Sometimes you can cooperate even if you're not cooperating would stop the bad act. And sometimes you can't cooperate, even if they'd find some other way of getting what they wanted. So you probably shouldn't sell an AK-47 to somebody that looks like they're going to go out and use it, even if they could get an AK-47 down the road at some other place. These factors suggest to me that one of the reasons we're worried about cooperation with evil is not about what it does to other people, but what it does to us. How it affects our own character and our own way of looking at the world, our own ability to do further actions, our habits, by tying up too closely to somebody else's wrongdoing. Here's another talk that could go on forever. I won't do that, but there's a whole category of Catholic moral theology called virtue theory, Professor Keenan has written extensively on this, and it talks about how your actions affect your own character. I think one of the things we need to do is pay attention to how cooperation with the evil acts of others can damage our character. I think there are two ways it can do this. Seepage. If you have a secretary who's typing her boss's blackmail letter, right? She's thinking, I'm just typing what he puts in front of me, or she puts in front of me. The examples are generally sexist from the manual, so it'd probably be a she secretary and a he boss. So excuse me for going along with those examples. At some point, and she's thinking, I'm just doing this in order to get my paycheck. At some point, she might say, well, I'm cooperating with my boss's blackmail plan, because she knows that that's how he describes what's going on, and she's connected to that, and she may start describing her action to herself in the same way that he does. And then that can lead to a different problem, self-deception. She may decide she likes the bonuses she gets because he's involved in blackmail. It can be a very lucrative process, you know, and way of getting herself some money. So she may start to deceive herself that she still disapproves of that when she's actually become a formal cooperator. She's intending his blackmail that she's facilitating as a means to her own end of making more money so she can buy a house in Newton, which I cannot believe how much costs, having come from South Bend. You could buy a township for the price of a house in Newton in South Bend. So those are a couple of the problems, I think, that are involved in cooperation. Let me just say one or two more things so that we can get to the discussion. How do we decide how close is too close? That's the second question that I think is a big theological question. I think what we do is we keep in mind the tension that we're living in the Christian world. The tension between the alreadiness of God's kingdom. We believe that with the death and resurrection of Jesus Christ, the kingdom of God is already in our midst. But it's not yet here fully. It won't be here fully till the second coming, to the end of time. So what we're doing when we're balancing cooperation questions, I think, is trying to decide whether we want to give weight to the prophetic witness to the kingdom of God being in our midst, the purity of our moral vision, the purity of what we're doing, the vision of God and the community as it should be among us, on the one hand, and the not yet, the pilgrims on the way to the kingdom of God. The not yet is messy. The not yet has sin, and the not yet requires the corporal works of mercy to clean up the mess. Catholic health care provides those corporal works of mercy. We wouldn't need people feeding the hungry. We wouldn't need people clothing the naked. We wouldn't need people taking care of the sick and the dying if we were in the kingdom of God. At the same time, if we engage in acts of cooperation that undermine the core of our message about the eschatological vision of the kingdom, in providing those health care, we're going to undermine our whole project. The tension between being true to the already, the purity and uncompromising witness, and the true to the not yet, which is recognizing there's a lot of mess and a lot of pain, and people need other people to clean it up, and that can involve cooperation. I won't talk about the last circumstance because I've already gone over, but I will say what the question is. We can talk about it. There are special circumstances today about cooperation with evil. Scandal, the question of scandal, which was just brought up, is part of that. But the big difference in today's context and in the time of the manuals is most of the questions in the manuals dealt with individual wrongdoing in a context where everybody agreed that the acts were wrong. We're dealing with whole patterns of wrongdoing. Lots of people are engaging in abortions or behavior that the church condemns, not just individuals. And at the same time, people believe these activities are right. So part of what we need to do in deciding how close and too close is too close, and how much scandal can we tolerate, is pay explicit attention to what the role of moral witness is in this place and time. Thank you.
Thanks very much to the panelists. I think we've got the complexity of the analysis out on the table. There may be questions about particular cases or questions about principles that need to be clarified, or just general questions about how cooperation works, and particularly how the interaction between the law and institutions and judges might work. So I open the floor to questions. Judy?
One of the great examples of tension in judicial context was when Lemuel Shaw here in Massachusetts, just about 6 miles from here, was faced with applying the Fugitive Slave Act when he had very much believed that slavery was wrong, and the fugitive slave gets brought before him, and he he had previous cases that he was able to dodge the bullet, find interpretations, kind of avoid the issue, but in the end, when confronted, and he was confronted with this issue, as history has said, he felt he faced that if he applied the fugitive slave law, he would be doing a terrible moral wrong to this man who had come before him, who had tried to escape freedom, but he feared for the destruction of the Union, and that question, and history, I'm not sure moral history has been kind to Judge Shaw in this decision, and I was thinking about would that have been this helped me think about his, how he would analyze his, but I presume the question is the proportionally grave reasons for the mediating the moral cooperation. Is that where analytically we push this on? And of course the devil's always in the details, like how do we say though, but by applying the law to this one person, is he in effect legitimizing the underlying law? And so I'm just interested, have you used Shaw's example, and where would his problem be situated in this moral analysis?
And maybe just to sharpen that the Fugitive Slave Act says you have to send the person who's escaped back to the owner. So the judge is going to have to issue an order that sends the escaped slave back to the owner. The judge says, the law requires me to do this. There's no other way to read the Fugitive Slave Act. I have to issue an order that sends this escaped slave back into slavery. I think slavery is a moral evil. I'm an abolitionist. What do I do? Can I enter that order? Or is entering that order culpable cooperation with evil? That's, I think, how I would frame the question. What do the panelists think?
This may be just sort of hindsight bias, but it's easy sitting here today to say that's at best impermissible material cooperation and may well be formal cooperation. The dodge that judges have today that they didn't have then is that the standards regarding recusal are different today. That I think it would have been difficult, if not impossible, under the recusal laws at the time for him to have recused and let another judge take his place. That's not true today. So there's an element of hindsight bias that makes it easier for me to condemn him, and there's an easier out for today's judges faced with what they see as a parallel situation, that is the option of recusal.
Okay.
I think that one thing that needs a lot more systematic work in the whole discussion of cooperation is role-related responsibilities in general. If you have somebody who's responsible for upholding the common good, a judge or a lawyer, a police officer, a fireman, there's a set of general role-related responsibilities that they've taken on, a kind of a covenant with the broader community to to generally obey the law and not necessarily to filter every decision through their own framework. So with a police officer, you use this example, I think, in your article, who is arresting protesters or trespassers at Planned Parenthood, a fire, would he be expected to do the job and apply the trespass law? The question is this a generally just law? Yeah, generally that law is just, so it's different from your situation. And so that even though it's applied in this particular instance due to a convergence of lots of forces, legal forces, in maybe what the policeman feels is an unjust way. But one of the factors I think we need to think about is what for the common good, stability of the overall community, what kinds of decisions do we want individuals making even though they occupy socially important roles that protect vulnerable people? That's different from what I do as a private individual in a capacity just as a private citizen.
The case that Ed mentioned, I think, is a really hard case. The case of the family court judge who's called upon to issue a ruling in a parental consent bypass hearing when there's a minor who comes before the court. Okay, so in order for a parental consent statute to be constitutional, there has to be a bypass provision that allows the minor to go to a judge and say, okay, I'm not going to go to my parents, but I'm going to go to a judge, and the judge has to decide, is this minor mature enough to make the decision on her own, or is the abortion in her best interest? So now this is the judge who has to issue this ruling. The judge has a conscientious objection to abortion, but let's say on the relevant factors, it's awfully hard for him to say that she's not mature enough to make the decision on her own. Can he issue the order that says, yeah, she's mature enough to make this decision on her own without being culpably cooperating in the evil if she goes forward and has the abortion? That's a really hard case, I think. And Ed said, well, I think that's something that judges who have a conscientious objection to abortion should recuse from. I had an interesting conversation with a group of Jesuits the other night, and there were a range of opinions on that. So, I mean, that might be something that we might want to talk about. Bob?
See, I don't buy this recusal situation, because I think by recusing yourself, you're passively cooperating. In fact, in Massachusetts, there are specific judges that hear these cases. They don't have any objections to abortion.
Right.
So judges that did have objection said, oh, I'm going to recuse myself, knowing full well that it's going to go to a judge who hasn't recused himself in the parental abortion. So there's an element of, I don't know if you want to call it formalistic, but I'd say passive cooperation. The individual is kind of off the hook, but just kind of off the hook. So this recusal notion, it doesn't solve the problem for me that you guys are.
I mean, do you want to speak to that, Kathy? There's a sense in which you were kind of referring to that at the end of your talk when you were saying sometimes when we know that the wrongdoing might take place anyway, we know there's a judge who's going to hear this case and issue the order anyway. How does that affect our analysis of the cooperation issue?
Well, it's one factor, but it's not the only factor. You might be saying that there's a duty not just not to cooperate, but I guess you could be saying one of two things. You could be saying there's a duty to protest, to actually protest, or you could be saying something which I think is a bit graver than that, which is there's a duty to actually subvert the law, to take the categories of what counts as best interest and rig them in a way so that you're deciding that there isn't an abortion. I mean, my guess is some of those statutes specify pretty clearly what counts as best interest, and they dismiss the well-being of the fetus as any of the factors in that. They're just looking at the well-being of the mother. So you could subvert the law, but I think that's moving well beyond cooperation with evil to active subversion. I mean, you'd almost need something parallel to the just war theory, because what you're doing is really undermining in a very deep way the way we think the legal system ought to operate.
And would that subversion of the law be greater damage to the common good?
Right.
And I guess I'm not suggesting that. I'm just saying that I'm suggesting that recusal doesn't seem to me to be an option. I think you deal with the law as it is and deal with your own personal consequences of that. So I'm not comfortable with the notion of passing the buck.
So you would never open the door to, it's interesting, in this particular instance, there may be a stronger argument for recusal than maybe in the death penalty context. For example, in the sense that the judge couldn't give an impartial ruling.
See, I think you take an oath to follow the Constitution, the laws, etc. And I think that's an important piece of what you're doing.
Right.
So you know, the fugitive slave law, for example, I mean, it's easy to say recusal wasn't as broad as it is now, let's say. But I still don't, I'm not comfortable with the notion of recusal because you're violating some other kind of moral...
Yeah, the norm to do your job.
The norm to do your job.
So you take the Scalia approach and say...
Yeah.
Well, I mean, that's why I think frequency matters, right? That is, if your job is on a day-to-day basis to be hearing abortion bypass cases, well, then if you recuse on all of them, you're not doing your job. If you're on a death penalty court and you recuse from all of those, then you're not doing your job. But I guess I don't see why one must jump to resignation simply because once every 10 years you have a case where you morally think you should recuse, any more than resignation is required because once every year or every 10 years, a corporation which you own stock has a case before you. In terms of that, it's that some other judge is going to do it anyway. Well, I think, as Kathy has noted, sort of that counts in the tradition as a factor. As a relevant factor in determining the appropriateness of the cooperation, but I guess what I'd emphasize there is that in an interdependent world, people have limited powers, so that unless a judge wants to engage in civil disobedience, and I agree that there reaches some point where the right thing to do is to revolt rather than to cooperate at all, and maybe that authorizes sort of subversion from within rather than openly taking up arms. But that's, I think, another question. But short of that point, it seems to me that resignation is overkill, and reaching beyond your duties is inappropriate. Just one last point on why I think it makes sense in this particular context to recuse. That is, almost all bypass cases will involve pleading in the alternative. That is, I am mature, and if you find I'm not mature, an abortion is in my best interest. I think there's a plausible argument that simply a finding of maturity is material rather than formal cooperation, although rather close.
Is it too proximate?
But it is rather proximate. But if in almost every case you're going to have to confront the possibility that if I find that she is not mature, I'm going to have to decide, is this in her best interest? It seems to me that it makes good sense from the perspective of the judicial system to say, well, don't hear it at all, rather than decide half of it and then pass it off to somebody else to decide the other half.
Jim, you wanted to get in here.
Yeah, I think that the instinct of the principle itself is against recusal. So I think that your own hesitancy to see this as a good strikes me as in the interest of the principle is of cooperation, so it is of being involved. And one of the key questions is, if I don't do it, who will? And that's a prudential judgment that has to be made. When the tradition first started doing cases, they were usually of, say, impoverished employees. It could be the messenger bringing the servant for the person seeking these assignations, or it could have been a kid working in a magazine shop that sold porn or something like that. But it was always about a certain sympathy that these people could remain in that position even though they were doing these actions, because we were trying to navigate how else could they survive. So it was really only in their interest. Then we started talking about judges. Then we started talking about people with power. We started talking about anesthesiologists. We started talking about all these people because we didn't want them resigning.
We didn't want judges who were presiding over divorce causes resigning for being in family court. We didn't want them resigning. We didn't want nurses resigning from healthcare facilities where there were sterilizations going on. We didn't want anesthesiologists. We constructed this principle more and more so that we wouldn't have to recuse ourselves. And then now finally we've brought it to an institutional level. Why? Because we didn't want Catholic hospitals to be closing down because of issues on, say, therapeutic sterilization. So the entire instinct of the principle is to question the whole question of recusal.
Kathy wanted to have one more.
Just one thing, and Jim, I don't know if you would agree with me on this, but I think the way you told the history is exactly right. That in the beginning, though, we were worried about, you know, poor people, vulnerable people who had jobs that were under semi-duress circumstances, so their well-being, you know, and it looked like it was their well-being off against whatever evil was involved. I think one of the new factors in cooperation in the contemporary context, be it judges or hospitals, is we're concerned about the good we can do for other people by cooperating. So it isn't just a question of, can I save the skin of myself and my family by, you know, I don't know, being Homer Simpson at the nuclear plant and, you know, doing whatever it is he does. So.
Adam?
Yeah, I'm a little unclear still, and this kind of goes off Professor Bloom's idea of passivity, but somebody glanced over, I can't remember who, but I'm a little unclear about the distinction between kind of just this being a means of washing your hands and I don't know what the other alternative is. I guess the way I keep seeing it is like a set of, and I might be coming at it the wrong way, but a set of compromises so that you can exist in an unjust world, which I understand on some level, but on the other level, I'm interested in the question of self-deceit and of self-betrayal, and just worrying about myself. Obviously there's a million other considerations, but on that front alone, like, how do you? It seems interesting to me. How is this not just self-deceit? How are you not just saying, well, I'm gonna on a small level, participate in something that's evil? Or how is non-participation not participating in evil, I guess is what I'm saying. I think about Gandhi and, don't participate in anything you believe is evil. Well, what does that really constitute? Because I feel like you could just we could wake up tomorrow in Nazi Germany, and that's okay, because we didn't actually do anything to affirm that or say it was okay, or, but, we're torturing people right now as we speak. We're torturing people in Guantanamo. I mean, I'm thinking from like a law student's perspective, like, what am I required to do? Not vote for people? Is that what I don't vote for those people? Well, that to me isn't drastic enough. To me, it's like, I want to go start knocking on doors. I want to start raising social gains. I guess it's a question of effectiveness in a sense too. I'm a little afraid that this is just a washing of the hands, and I'm trying to figure out the distinction, so somebody can help me on that.
Yeah, I mean, there's questions of self-deceit, there's questions of character formation and deformation, there's questions of not only how do I make my way in an unjust world, but how do I do good in an unjust world? How do I use my vote in an unjust world? That's an issue of cooperation. So voting is an issue of cooperation. Legislating raises issues of cooperation. But I don't know if somebody on the panel wants to speak more directly.
There was a famous case in Germany that involved the Catholic Church. And that was that if a woman wants an abortion, she needs to receive a notification that she has gone for counseling. And a group of different German Catholic churches wanted to provide that counseling. Now, the only way that the woman can secure it is if she receives, at the end of the counseling, this this card that says that she did attend the counseling, and there she's going. So the Catholic Church had this debate. Do they stay in and participate in the counseling and therefore enter into her own actual decision-making, or do they recuse themselves from it? And the president of the Bishops' Conference in Germany, Cardinal Karl Lehmann, fought vigorously on this issue, but eventually lost to another German cardinal who's now the Pope. But that is a prudential judgment. That's what makes a prudential judgment.
And Lehmann's argument was what, just to be clear?
Well, his judgment was that by being involved in this act, it was a form of cooperation. It was a mediated form of cooperation because and it was approximate mediate form of cooperation, but Cardinal Ratzinger was really more concerned about the scandal that would be demonstrated that the Catholic Church would somehow have a participatory role in this. So Lehmann was taking these categories that we've been discussing, and he would say that there was certainly no formal cooperation. The reason why they're saying in it is to dissuade the woman from an abortion. The second is that they want to, and therefore they're not, their object is material, not a formal issue. They're not intending this to occur. But it's also not immediate. They're not directly involved in it. That's what cooperation is. You can distinguish they're providing counseling. They're telling her all the issues related to an abortion, including negative issues about having an abortion. But the issue was that the only way she can secure an abortion is by getting this notification card. But she can get that anywhere, which goes then to Kathy's point about indispensability. It was, for us, a classic case of immediate, proximate, material cooperation that was not dispensable.
So Cardinal Lehmann is saying the church could do some good by being involved in this counseling process, but Cardinal Ratzinger is saying there's too much scandal by the church's participation in this.
And that's a good, I think that's a good point. I think it's very important. You have to look at what's involved in the cooperation. If you say to your best friend, promise me you talk to me before you get a whole set of body tattoos, so I can talk you out of it. Your goal is to try to talk them out of something that you think is an enormous mistake. And in a way, the church, this is an exaggeration, but it's a little late at night, so we'll try. But what the counseling was not totally morally neutral counseling, but counseling to make sure that the woman saw this as a very last step that had tremendous consequences both for herself and the baby. And to differentiate that between sort of giving somebody something that's going to facilitate something and making yourself kind of a barrier, but not a total barrier to their doing what they want, I think shows the problem that you just brought up, the student who just asked the question, how do we think about washing of our hands versus, moral purity? Two things have to be said. One is Catholic Church teaches, and it's in Gaudium et Spes, that a sinful act does more harm to the agent who does the sinful act than to the victims of it. So, a virtue-centered ethics say that we do more harm to ourselves by doing evil. So there is a sense in which we've got a whole way of looking at moral theology that doesn't see the consequences for other people as decisive as the consequences for the agent, although they're terrible under many circumstances. Sometimes the notion of moral purity can be used to cut down the categories of concerns you have to look about. If I just think, well, if I don't do anything, if I don't contribute to anything, then I'm not going to be cooperating with evil. What kind of a person is that? And how do you respond, to Matthew 25, where, it's whatever I did, if I was hungry and you fed me, if I was thirsty, you gave me to drink. That's the criteria that we get for the last judgment. And sometimes being involved in that is going to be, you might feed somebody who's going to turn out to kill somebody.
I'm sorry. Go ahead.
That's precisely why I think it's worth talking about cooperation, not simply in isolation, but in connection with other aspects of charity, because the concern is with the agent. That you're not just trying to keep your hands clean. It's why the example that I point to of recusal is sort of the extreme limiting case. That the vast run of cases where Catholic judges have something useful to contribute to the common good by participating, I think there is no need for recusal on it. So it's a small limiting category. And the last point here is, particularly coming off Jim's point about the German example, it increasingly seems to me that people who are people within the church who are critical of cooperation are really concerned about scandal.
Right.
And they keep saying the word scandal, right, and nobody knows what they're talking about.
Right, exactly.
And what somebody might usefully do to judges is say, here's what we're worried about. We're worried that people are going to see that you're a good person, you seem to be approving this bad thing, so they think it's not so bad. Here are some suggested ways on how you can reduce that risk. Seems to me that would be a very productive thing for somebody to contribute.
Jim?
That's a good point. And to follow up on that, the third consideration, the possibility of scandal, seems to be in the background of a lot of the prior discussion. The question about role-related responsibility, perhaps, is probably a scandal question. Surely scandal cannot simply mean bad publicity.
Right.
I would hope it doesn't mean bad publicity. I would hope that it is looking at the effectiveness of the church and people of goodwill in helping to further the mission of our faith, in helping other people and helping achieve good works. And if that's a broader view of scandal, then it strikes me it becomes more almost of an efficiency type analysis. Or as a tax lawyer, we would think of it as an efficiency, or maybe I should say an effectiveness. To what extent is it going to impact the effectiveness of the institution in achieving its positive mission? I was wondering if maybe the panel could expand on that a little bit more, because I think that it underlies a lot of the questions that we've been discussing.
And I think how to think about the question of scandal properly would be very helpful to hear more about.
It's basically coming from St. Paul. I mean, it's coming from the whole pericope about the whole his whole solution about idol meat. You know, there's all the meat in the market has always been left out for idols, and you know, real robust Christians look at this and they say, well, there's no problem, we don't believe in the idols. Well, what about the weaker members of the community who think that you actually don't really care about whether or not you're worshiping an idol or not? So that's what the scandal is about. Do you lead another person into sin? That's what I think Ed was saying earlier, and I think that's what we all understand the issue of scandal to be. Would it lead other people into sin? That they think that we're saying this is fine to do on the grounds that they're understanding it. So in the St. Paul case, I think it's 2 Corinthians 7. I should say St. Russell's 2 Corinthians 7. But in there, he's simply saying, I should not mislead, and I should be concerned about those who cannot understand this, lest they think I'm doing something that I'm not. So in the case in Germany, Cardinal Ratzinger is effectively saying, if we get involved on a large scale with a church in the entire procurement of abortion services, we will be leading people to think that abortions are not that grave of an issue, and therefore some people may end up procuring an abortion who previously thought it was a grave evil. So that's what we mean by scandal. I think that's
Yeah, I mean, I've got the definition from the Catechism, which is not very helpful. Don't write them and say I said that. Scandal is an attitude or behavior which leads another to do evil, 2284. Anyone who uses the power at his disposal in such a way that it leads others to do wrong becomes guilty of scandal and is responsible for the evil that he has directly or indirectly encouraged.
Right. And that's interestingly framed in objective terms,
right,
rather than in sin terms,
right,
rather than in subjective terms.
But I think it's even more than scandal that's at stake. If you look at what's going on up in, Holy Cross, your fellow Jesuit institution, maybe we could take, one of these cases that's out. Holy Cross apparently is got
the rental.
Their, what are they called? I wrote this down somewhere. There's a big conference on dealing with teen pregnancy going on up at Holy Cross, and there's a whole bunch of organizations who are coming in to, I think, what's the Holy Cross kind of conference center, and they're a whole different group of people coming in. They rented it out to this group since 2001. Well, 2 of the sort of booths in this big conference on dealing with teen pregnancy belong to, I think, Planned Parenthood is one, and NARAL Pro-Choice Massachusetts is another. So you get little booths inside a big conference that's renting out the conference center at Holy Cross that's rented out all the time, and there was a big kind of problem that people raised. Pro-life activists, wrote the bishop, and the bishop, I think, issued a letter that said to Holy Cross, you know, you got to stop doing this. You can't do this or you're not going to be a Catholic institution. Well, if you think about the cooperation with evil framework, you know, it's really remote. Really, you know, you've got the abortions, you've got the contract, you've got the conference center, and people have got a couple of booths that are advocating things you don't agree with. So this looks like very remote material cooperation. So where's all the energy coming from? It is the scandal issue, not just in leading people to sin, but in I think there's something more, compromising the ability of the church to have an unequivocal prophetic witness against, you know, abortion and these sorts of behavior. So the relationship of prophetic witness and the requirements of that are even more, I think. They overlap with scandal, but they're not entirely related to it.
I think that also the confusion often starts in hospital administration. We got a call from a member, and you probably know about this, that there was a very high-risk pregnancy coming into one of our member hospitals for delivery, and it turned out that it was a grandmother delivering her grandchild on behalf of her daughter who could not carry a pregnancy. So the switchboard, of course, lights up with all the hospital brass calling the chancery and saying, this is going to be a terrible scandal. And the response was, get out there, smile, and say that you welcome new life, you've saved a mom's life, and that you've done good work.
Exactly, and I think that's the point I wanted to make. If it's concerned about perception, as lawyers, we engage in communication. That's what we're trained ultimately to be, communicators. So it almost seems to me that scandal takes a very secondary role, because if we're doing our jobs correctly, we're creating the spin or the hook that's going to capture the attention of the public that allows them to see that there is a good that's being achieved here as well. That won't mislead them into thinking that the church says it's okay, but rather that the church is saying it's important for us to be a player because we have something important to say and we have something important to do.
Yeah.
So I find the concept puzzling.
But I think that was the point I was trying to make, that as the principle of cooperation has gone from employment issue to personnel who have influence in a particular institution to institutional, this was saying we need to stay involved or we need to become more involved. And the principle isn't used to validate what you're doing. It's really used heuristically to guide you toward what needs to be considered. So now that we see it being used institutionally, we see that the will of the healthcare centers and the Catholic universities is to figure out how to stay involved as opposed to not staying involved, and to demarcate what are the more problematic issues. So I do think that what one has to see is, even though the bishops of Germany are not doing this action, or even though we've seen recusals institutionally or personally by other agents, for the most part, it's employment, and even that we're having this discussion here is an indication of how much the Catholic institution or the Catholic person is trying to stay in the complex world that we live in. So I do think it's a clear indication that we're trying to figure out how to do what we need to do.
Another way to say that maybe is withdrawal to be a prophet should be a very last sort of resort. If there's lots of good that can be done by staying involved.
That is the area, though, of the Catholic Health Association document that I'm less sure of. I do think there is tension, not between avoiding scandal and the principle of cooperation, but prophetic discourse and cooperation. I wrote an article on prophecy and casuistry, and this is a type of casuistry. What the pro-life movement would say, and I'm more casuistical on this, but so you face it, is, suppose you are having a discussion at Holy Cross, and there was the Ku Klux Klan was coming in on talking about race relations, and they were a booth at this conference on how to deal with race relations. You would never permit that, you would never allow that, you draw the line there. So what they're trying to say is, why are you not seeing this issue in the same way that you would see these other issues? Why are you drawing the line on this case if what you think is true about what abortion is here, but you wouldn't say on race relations? And that's always, prophets don't play nicely with kind of ordinary categories, and they challenge us on them.
Just when we're on this, and with regard to judges, judges are casuists.
Right.
They're not prophets.
Daniel?
One of the things that I found very kind of concerning, and I suppose this is just anecdotal, is the kind of checking out of kind of the chaos of this world by people of faith. In the sense that when I went to law school, I was told I was a sellout, a sophist, and all of these things for not going and studying philosophy, which is my undergraduate major. I had someone tell me that I was a prostitute, an intellectual prostitute for studying law. And I like the law because the buck stops there. Like, you have to make a decision. You know, you can't just say, well, you know, Plato says this, and Aristotle says this, and, you know, and we'll just agree to disagree. Like, you can't do that. But I think it's a real fear to me that you're seeing, especially with the politicization of judges and all of these things, that you were seeing, you know, the first thing that's said about Judge Roberts, regardless of what you think of his politics, is that he's Catholic, you know, and that because he's Catholic, automatically, well, we should kind of not be overly concerned with what he thinks, and that he couldn't possibly have some legitimacy to what he thinks, regardless of what you think of his politics. And I guess my fear is, how do we deal with that as church, as a Catholic institution, of reaching out to those who are people of faith and saying, you're legitimate, your position is legitimate, and how do we get that voice into the public square and really engage in the chaos of the world and say, like, this is what we think about abortion. This is why. And it's not just because we're Catholic, you know? Or I guess, like, that's kind of my question, is that what do we do about people checking out that I see a lot of my friends doing?
Who wants to start with that one? You get to start with that one.
Yeah.
Boy, I guess my instinct is just that it's at some level too easy to check out. That's sort of if I were sort of talking to your friends, I think what I'd say is, well, that's too easy. That it's too much of a, I want to escape from the world to keep my hands clean and not do and not have the engagement that's required, whether as a judge or a healthcare worker, to do the good that can be done in the world around you.
I was thinking earlier when Dr. Bloom had said that the judge has taken an oath to uphold the Constitution. I still think, though, that there's that the very issue is, how do you interpret it? And the act of interpretation is not done with, clear glasses. I think what we find is that everyone brings their whatever basic social traditions they belong to, whether they're religious or humanistic or whatever, they bring their own personal conscience, which is not often in sync with their fundamental community of faith or community of peers that they belong to. And they also have the task of trying to interpret the law as it exists. And it just strikes me we can't be talking about such persons as able to detach these dimensions of themselves. I know that people will say that they can, but I find that unbelievable. Just as a simple aside, I had done this talk at MIT, and I had mentioned that we have multitudinous motivations in acts of interpretation. And there was like this mantra going on, until finally I understood they were saying a pure desire to know. Because they believed as scientific researchers, they were capable of an innocence as they approached any type of research. And they said, lawyers, you have complex motivations, and many of them are bad. As well, I'm not a lawyer. Priests do have lots of complex motivations, and now we know they are bad. But we're scientific researchers, and I find this naive self-understanding of an agent who singularly functions to interpret a law that doesn't go into the nature, what Kathy's been bringing up the entire evening, the character traits of that agent. How are his prudence and their self-care and their sense of justice and their sense of fidelity, how all these converge in the actual judgment as something that inevitably is engaged. And to say otherwise is to be, in my book, epistemologically naive.
Another dimension of that is, how does the church speak to public officials? And if the church is always telling public officials, you must do X because you're Catholic, because the church teaches this, then that's going to raise questions in people's minds about what's going to happen with Roberts.
Right.
And so I think it's important, if we want to have a productive conversation about this, to speak in ways that say, okay, here's the arguments why this is so. Here's the arguments about the morality of this act, or here's the arguments about how to interpret the Constitution on their own merit, not because Bishop so-and-so says so. That really, I think, makes it difficult to have a productive public conversation about this. So it's how people of faith should act in the world and how they should speak in the world and how the church should speak in the world is complicated. Now, I think the church needs to speak in the world. We need to be engaged in the world. But we have to do that in a way that doesn't seem like all the answers are coming with authority and there's no room for any more conversation.
I was wondering if you could take that one step further and say, if the members of the panel would say something about the role of the church in political campaign. This whole idea that they won't give communion to a candidate who's Catholic and espouses a view that may be against the church. The idea that from the pulpit, some priests have accused people of wrongdoing because they had a political button for a candidate. What should the role of the church be in this matter of political campaigns?
Does anybody want to speak to that?
Well, I think the church has to be clear. But first of all, the conversation shouldn't lose its context, and which is easily done. And the context here is social responsibility in a democratic republic, the common good, the issues, and talk the issues. We were perfectly free to talk the issues. And I think to leave it there. Now, I was on Cardinal McCarrick's group that talked about communion and politicians, and the result of that. I now reside in St. Louis, and
oh my goodness!
I don't know that. Oh, you don't know that? Oh, yeah. And so that's a whole different wind blowing. So
you should explain what that means.
Okay. Archbishop Burke has announced last week that he will bring this back to the attention of the National Conference of Catholic Bishops in November. So, and he's very much opposed to pro-choice politicians receiving Holy Communion in the Catholic Church. So there's that voice out there. And so it's, back in the old days, we used to talk about who would do a tubal ligation in a Catholic hospital as regional morality, and that's certainly the impression we're giving now. Personally, stick to the issues and keep the context open. Motivate to vote rather than motivate against voting against somebody. I think that's a very important step, because it's something to do otherwise cheapens the democratic process at the local level.
Thank you very much. Oh, I'm sorry.
Just a quick question.
Very quick, Ray. Thanks.
I think less controversial than everything that's going. So maybe a boring note to end on. But first, I just wanted to say that I thought a lot of the comments from people that are wanting to see how this is more than just washing your hands. It has to do with the difference that's been mentioned already between the kind of scrupulous conscience that was more common in the Catholic Church for a long time, as opposed to maybe a more easy conscience, which is more popular now, and that the test of the principle of cooperation is going to be whether, excluding considerations of scandal, whether it can really cut both ways, whether it can solve an uneasy conscience and really perk up, really get going a conscience that's too easy, more easy than it should. So then the question is, and this is the boring part, how do you determine an intention for an institution? You've got healthcare, and is it possible for a healthcare system to participate formally in something? And is there an intention of an institution?
Sure.
When you talk about
we
the
had a
corporate
famous
conscience.
case, it was ludicrous, that it was a Catholic hospital, I don't know, we won't say what state it was, but this Catholic hospital wanted to say that they were under duress providing therapeutic sterilizations, and so they had this room where they put over the door, you're now leaving the Catholic hospital, and you're going here. But they were doing this not because there was any need. There were therapeutic sterilizations in another hospital. They were doing it to be competitive in the market, and that's what we would call implicit formal cooperation. They were saying they weren't doing it, they weren't under constraint. And this led to this whole problem of editing out the principle of cooperation, because a hospital like that misused what we had done. And several of us were calling for them to lose their Catholic identity. We wanted to do it because it was evident that they were pernicious in their interpretation of this. But that's a clear example of when a board and its president formally, cooperate in evil. And we wanted them to hang. On that happy note.
On that happy note, thank you all for coming. Thanks to our panelists for a wonderful discussion.